Chapter 1 General Characteristics of Intellectual Property, Part 2, 1 to 4. World Intellectual Property Organization, WIPO, 2 legal notices of intellectual property objective after this presentation. Students can illuminate WIPO, interpret the general notion of intellectual property. 1 to 4 World Intellectual Property Organization, WIPO. 141 History of the World Intellectual Property Organization. The World Intellectual Property Organization, WIPO, is a specialized organization of the United Nations. WIPO was founded in 1967 to encourage innovation and promote the protection of intellectual property in the world. WIPO currently has 193 member countries, 26 international treaties, and is headquartered in Geneva, Switzerland, such as the Paris Convention and the Berne Convention. 142 Mission and other activities. WIPO's mission is to promote international cooperation in the development, promotion, and protection of man-made works for the economy, culture, and society. WIPO's cooperation for development programs is working closely with governments and intergovernmental organizations, including the WIPO WTO, to assist developing and developing countries to implement the WTO and TRIPS. Importantly, today helps to promote intellectual property to be recognized as part of daily activities. Establishment of multilateral treaties, legal standards, provision of global IP services, registration of national political system of IP, promotion of knowledge and use of IP. 143 Administrative structure. The WIPO Establishment Convention has 4 main structures: the General Assembly, the Conference, the Coordinating Committee, and the Office of the Secretary General of the International. 144 Membership. To become a member, each state must submit a national instrument to the Secretary General of WIPO. 145 Director General. WIPO is headed by a Director General and a number of Deputy Directors General. Francis Gurry, who has been in charge of WIPO since October 1, 2008, and was reappointed in May 2014 for a second term until 2020, and now Darren Tang is the CEO. 2 legal notices of intellectual property, 2-to-1 definitions and special principles of intellectual property. 2:1-to-1 Definition. A. Ownership. The property that you are familiar with belongs to heritage and non-heritage property. Inheritance rights are tangible and transferable rights, including monetary rights, including real estate and intellectual property. These properties, such as land, houses, cars, mobile phones, all belong to the heritage you can see, touch, or hold. Especially can be mortgaged to transfer ownership temporarily or permanently. You can evaluate the business by looking at it, measuring the size, or you can place the price in comparison with other similar assets that belong to the heritage. Intangible ownership, on the other hand, is a bit difficult. You cannot hold, cannot touch, but can be recognized through intellectual knowledge. If you are a businessman, you have the right to trade. If I am a writer, I have the right to compose songs. The right to trade. The right to compose songs is an abstract right. Business card. Non-heritage rights. These are intangible, transferable, and inalienable rights, such as the right to liberty, the right to entertainment, the right to freedom of expression, the right to participate in political parties, and the right to vote. Intellectual property. Ownership is the result of human innovation. Intellectual property is divided into 2 main categories: industrial property and copyright. Geography, trade, trade secrets, disclosures, patents, useful models, industrial drawings, compact circuits, crop protection and breeders, public health licenses, satellite communications and traditional culture, traditional dance and traditional knowledge. B. Why do we need personal ownership? There are 3 major theoretical rights of human beings. John Locke lived, had freedom and belonging. and these rights were enshrined in law. Because each of us wants ownership because it is easy to manage, use freely and enjoy. 2.1.2 Special Principles of Intellectual Property. A territorial principle is a principle to be protected in its territory. B. The statute of limitations is a principle that must be protected for a period of time, clearly defined according to the type of work or type of ownership. See the principle of monopoly to encourage those who strive to create by giving exclusive rights to the owner.